Good afternoon, guys. Good afternoon. My name is Alina Sholtsova. I'm an immigration attorney from New York. And in today's live video, I'm going to talk about Ukraine and the new decision by the United States government to designate Ukraine for TPS, or temporary protected status. I'm going to talk and provide you with some updates that will be relevant for those who are in removal proceedings, the way the government started handling certain removal cases. And of course, we're going to talk a little bit about USCIS work permit backlogs and what USCIS is currently doing to resolve the backlog. So thank you very much for joining. The portion of the video, or the portion of the presentation about TPS for people from Ukraine, I will also repeat in Russian language after I'm going to be done with English version, because I receive comments that Russian speakers would need this information in Russian. So just be patient with me. And please share this video so it will reach people who may benefit from it. And again, my name is Alina Sholtsova. If you have not sign up for my channel, if you do not know me, I'm an immigration lawyer. I've been an immigration lawyer in the United States for, I guess, 15 years or so now. And thank you very much for joining me. Let's start. We just received the news. By the way, let me know where you're watching from. Let me know your name. Don't forget your questions. After my presentation, I always answer your guys' questions, and I'll be happy to do that as well today. So let me first of all start with the news that Department of Homeland Security designated Ukraine for TPS status. TPS status is a status that allows somebody from a certain country to reside in the United States and to obtain work permit and travel permit, so that they will be able to leave the United States and come back while they are in this status. So today it was announced that Ukraine is designated for this status. It means that Ukrainian citizens will be able to apply for this status and will be able to stay safe in the United States. Currently, the designation is for 18 months. But as we've seen in the past, it can be extended and extended. It's very important to know that. Who may apply for this? Well, first of all, you need to show that you are a citizen of Ukraine. And second, you need to show that you've been residing in the United States since March 1st, 2022. So as long as you entered the United States prior to this date, you will be fine. There may be a little correction when the notice is going to be published, because a person will be able to file for the status only after official notice is published in Federal Registry about the status. So there may be a little correction as to whether or not you can file for the status if you arrived on March 1st. This is extremely important. Hi, Romain. And currently, the language says since March 1st, okay? And if you entered without inspection, you crossed the border through Mexico, for example, and the United States. If you're already in the United States for a long time and you're waiting for some application that is pending, or you're waiting for your removal proceedings, you are in removal proceedings, or if you are waiting for asylum interview, you will be able to qualify for the status as long as you pass certain background checks. What are those background checks? Well, usually you have to show that you do not have certain disqualifying criminal convictions. This is what those checks are. Okay. Now, TPS status will not lead directly to green card or citizenship unless there is an immigration reform that passed. But it will protect an individual here, and I encourage strongly every person who is from Ukraine to apply for it when the application period will be open. Very, very important. Now I will repeat the same information in Russian, so please be patient with me. Здравствуйте, меня зовут Елена Шевцова, я иммиграционный адвокат. Я уже опубликовала небольшое видео на моем канале о том, что сегодня правительство США одобрило специальный статус для граждан Украины. Чтобы квалифицироваться на этот иммиграционный специальный статус, человек должен показать, что он не только гражданин Украины, а также, что он находился на территории США с 1 марта 2022 года. Если человек попытается сейчас заехать на территорию США уже после 1 марта, к сожалению, человек на этот статус не сможет претендовать, если только правительство не поменяет дату 1 марта на какую-то более позднюю дату. Пока заявки на статус подаваться не могут, но вы можете к ним подготовиться. Почему не могут подаваться заявки, несмотря на это объявление? Потому что правительство по процедуре должно опубликовать вот эту информацию в специальном регистре. Но после этого будет открыто окно, обычно это 6 месяцев, в течение которого люди смогут подавать эти заявки. Если вас одобряют на статус, вас не могут депортировать. Несмотря даже на то, что если против вас уже есть какой-нибудь старый ордер о депортации. Если вы въехали в страну нелегально, если вы перебыли свою здесь визу, когда-то давно, может быть, въехали, либо вообще въехали без всякого статуса, да, перешли границу, вы сможете подавать на этот статус. Так же, как и те люди, которые, например, в студенческом статусе или у них рабочая виза. Все смогут подавать. Только нужно показать, что вы были здесь, находились с 1 марта 2022 года, и у вас нету каких-то определенных преступлений, которые будут препятствием на подачу к этому статусу. Очень-очень важно это знать. Статус не может передаваться от члена семьи к члену семьи. Например, есть супруга получает этот статус, она не сможет никак спонсировать другого члена семьи на этом статусе. Каждый член семьи должен квалифицироваться на этот статус отдельно. Очень важно это знать. Ну вот, пожалуй, главная новость сегодняшнего дня. Пока никаких других новостей нету. Будем смотреть, может быть, правительство одобрит какие-то другие меры еще. Как только будет известно, когда можно подавать заявки, я вам обязательно дам знать. Большое спасибо за просмотр. And now we'll go back to other news. Thank you very much for being patient with me. I'm going to go back to other immigration news that may be relevant for wider audience. For example, it was announced that currently, for those who are in removal proceedings, the government practices something called affirmative dismissal of their cases. It means that when the government themselves, they review your case and come to a conclusion that you may pursue the same relief before USCIS, they may file a motion with a judge to dismiss your case. So you will have to refile your case with USCIS. This, of course, helps to resolve the backlog, but for some people it may be not a desirable outcome. Current processing times in USCIS are extremely long, and this particular relief will be relevant, or particular situation will be relevant for those who are filing for adjustment of status. Sometimes a person may want to stay in court to pursue adjustment of status because it will be faster for them. So watch out if your lawyer receives such a motion to dismiss, and then the lawyer will have to talk to you if you want to object to it or you want to agree to it. This is just something very important to know for everyone who is in immigration court proceedings, pursuing relief that also may be pursued, I believe it's mostly adjustment of status, before the immigration court. It's not going to be true for those who are filing for asylum in immigration court after they already submitted their asylum and were referred to court from USCIS. Very, very important. And finally, I also wanted to mention about work permits. Many of you are waiting for your work permit. Many of you are asking me what's happening with that. So the most recent news is that in attempt to resolve the backlog, USCIS now is processing applications for work permits and travel permits separately. You may not receive a combo card anymore. that card that will show that it's a work permit and authorization for travel, you will receive 2 separate documents. You're going to receive, if both are approved, you're going to receive a green card. A green card later. Yes, you will. I hope so. You're going to receive a work permit card separately and approval for your travel documents separately. So when it happens, just don't be upset. This is what's going on right now. In an attempt to resolve the backlog, this is what's happening. Okay. So now, guys, if you have questions, please type them up in the chat and I will be very happy to answer them. Hi, Romain. Hi, Eric. Hi, Cole. Hi, Eric. I'm following you from Brooklyn. My question is there any chance to accelerate I-485 approval? Is there any? How can I do that? Very good question. Yes, there is a chance, depending on your situation. Okay. USCIS generally stated that they will accept and consider request to expedite decision on any immigration benefit if you meet certain qualifications, criteria. So you can go on USCIS website and see what those are, okay? But usually you have to show that you need the status, and the fact that the application is not decided causes you extreme hardship of some sort, or that it's in the benefit of the United States. For example, your I-45 is based on employment petition and your employer experiencing hardship, or a non-for-profit organization, right? There are some other positions when you can ask for it, but this would be your first attempt, is to read those guidelines and to submit your request to adjudicate as fast as possible based on those guidelines. Now, what to do if that does not work? If that does not work, you can also try to expedite your application by requesting assistance from the Congressman's office or USCIS Ombudsman's office. 2 different places, so you will have to choose which one you want to use, okay? I would suggest probably Congressman's office. I find them to be very effective, but this would be another way. In cases where I-45 or any other application is pending for a very long time, you may consider the last option, which would be a lawsuit. I personally do not recommend unless the situation is outrageous, okay? This is something that you may consider and discuss with your attorney. But these are the options, right? Hi, Tony. I'm all right, thank you. Hi, Aslan Beck. Hi, Alina. Is there a way to find if and how many days you have accumulated in unlawful presence? Well, sure. You have to count them. You have to know your status that you have, right? Throughout your stay in the United States. If you filed for anything, if anything was denied, right? Because unlawful presence is a very interesting thing. Sometimes it doesn't start to run when you fall out of status. For example, you were first in J1 status or F1. Just because your status was terminated, it doesn't mean you started to accumulate unlawful presence, because you were admitted for duration of stay, duration of status. If you have an application pending, for example, you have a duly filed and accepted asylum application pending or adjustment of status application pending, unlawful presence is not running. Persons under 18 years old do not accumulate unlawful presence time. So we need to gather all information. Sometimes if you're not sure what you were filing for when the denial came, you need to order copies of your files, and then you'll be able to count with an attorney how many days of unlawful presence you have. For immigration purposes, what will be relevant is 180 days or a year. Why? Because these are the marks that we use to determine if someone fell out of status to the point that they may face unlawful presence bar or not. Okay? And for adjustment of status purposes based on work related petitions. You also have to calculate how many days of unauthorized employment you've got, because that's maybe relevant as well, right? For different purposes, those days may be relevant. Hi, Shahzad. What are the chances of getting approved of Y-130 after placing and removal proceedings? Just like with everyone else, like everybody else's chances, of course, your burden of proof that your marriage is real is higher if you got married after you were issued a notice to appear. But if you do not have allegations of marriage fraud, right? If you can present strong evidence that you in fact have a real marriage, then you have very good chances. Why wouldn't you? Right? You don't have a bar, you have proof, you should be fine. Hi, Yulia. Hi, Alina. I'm Ukrainian who is currently in the United States and I have pending asylum case. Do you recommend to apply for TPS? Yulia, I cannot give this recommendation specifically for you because this is not a consultation. But generally speaking, every person who is in the United States, regardless of what pending status they have, they should file for TPS when the window will be open, okay? So this is very, very important. Why? Because if you don't do this, if you don't file for TPS, you will not be protected in case something's gonna go wrong with your asylum application, okay? So it's very important to know that, very important. Hi, Ohineba. Please help me with this question. I'm in removal proceedings. My I-130 got approved recently after interview with USCIS. I have filed I-45 with EOIR. Do I qualify for work permit? Yeah, if your I-45 is pending, you should be able to file for the work permit. Only I'm going to tell you, chances are you're going to be waiting for it like forever. Okay, forever. So, I can say you qualify, but I'm not sure what's going to happen, provided that you're adjustable. Sometimes I've noticed that if you filed I-45 when you're not qualified for adjustment, then you may have a denial, all right? But you need to show that your I-45 is pending. Then why wouldn't you qualify? It's pending with a judge, right? Duly filed, pending with a judge. Your attorney did defensive filing. To my knowledge, and I may be wrong, okay? Why I may be wrong? Because we all may be wrong. But to my knowledge, you should be able to qualify. In the past, I filed such applications. They were not denied, but I'm going to tell you that I never received a decision. All right? So that's why I say I may be wrong. But you should. So should the applicants for cancellation of removal. If a person files for cancellation of removal, they qualify for the work permit while they're waiting for the cancellation of removal. But in practice, that work permit may stuck. Hi R, can anyone email or send a letter to the President of Government and ask for a pardon for false claim citizenship? False claim of U.S. citizenship, were you convicted of it? Because the President, I understand, or Governor's pardon can be obtained when you have a conviction. What you may be asking about, it's called private bill. Okay? If you do not qualify for any exceptions to the claim of the U.S. citizenship, which there are very few, there is a private bill, which in theory is available. Private bill is when you can demonstrate that a special law shall be passed specifically for you. That's what private bill is. Pardon is usually for those who were convicted of something. Okay. Hi, Tony. Hi, Alina. If someone is approved the advance parole by immigration judge, can someone who just got married with a spouse approved advance parole, maybe adjustment of status? Immigration judge cannot approve the advance parole because advance parole application is in the exclusive jurisdiction of USCIS, to my knowledge. Can someone who just got married with their spouse of the United States together with the application, enter the United States together with the application? Let me read it again. If someone is approved their advance parole by immigration judge, can someone who just got married with their spouse enter the United States together with the application? usually to be able to travel. I think I'm a little bit confused here. Usually for a person who is a non-citizen, right, to be able to travel to the United States to enter, they would have to have a visa, advance parole, or boarding foil, or green card. If you have that and they're valid, you should be able to enter, right? But if you're in removal proceedings, let's say you obtained this advance parole somehow a long time ago, then you were placed in removal proceedings. Don't travel, all right? Consult. I would say that please ask this question, present this question to your attorney, because I may be just a little bit confused about the situation, okay? Usually to enter the United States, you have to have one of those documents that I mentioned. Hi, Amar. Hi, Aslan Beck. Thank you. No problem. Hi, Nia OTR. Hi, Alina from Illinois. First of all, thank you a lot. No problem. Helps people. Can TPS adjust it to non-removable status or green card? TPS is exactly a protection from deportation. Once a person receives TPS, the government cannot remove them from the United States unless the person does something, usually a criminal act, or fails to re-register for the TPS, loses TPS status. Then the government will be able to remove them. But TPS protects you from deportation, right? However, currently it does not lead to the green card. TPS дает вам возможность находиться на территории Америки, и вы не будете депортированы физически. Это невозможно, когда у вас есть TPS. Только если вы потеряете этот статус. Например, совершено какое-то преступление, и вы потеряли, больше не квалифицируетесь на статус, либо у вас правительство забрало статус, либо вы вовремя не подали на продление. Но TPS не приводит к тому, чтобы вы могли получить грин-карту в настоящий момент. Если поменяется законодательство, то сможете. All right, guys. Well, thank you very much for watching. Please share this video. Maybe it will help somebody. Thank you very much for your words of compassion. We're all going to work together to try to, all immigration community gets together to try to help refugees, people who find themselves in very, very difficult situations. And I'm sure that many other lawyers are going to share very useful information as well. So thank you again. Please share this video if you can. Sign up for my channel. I always publish the most recent immigration news. I try to do it as soon as I receive them, minutes later. So thank you again, and I hope to see you soon.